Okay, the next case on our docket is Schramm versus Adams Homes of Northwest Florida and Shoemaker and Son Plumbing, 24-0445. Let me take a moment to say, obviously, you both get 20 minutes per side. You don't have to use it if there aren't any questions from the panel. I also want to make a comment. It's typically not my practice to introduce my colleagues. Like some of my colleagues, when they're presiding, they do introduce themselves, and I've seen the wisdom today of why it is important to introduce my colleagues. It's Judge Adrian Soud. It rhymes with loud. So it's Judge Soud, and just to my left is Judge Paige Kilbane. So this is Scott Makar, not Mocker, Macker, or whatever. So with that, please proceed, Mr. Lee.
Thank you for the introduction, Your Honor. May it please the court, Brian Lee representing Robert Schramm on appeal. This case comes to the court from a summary judgment, as the court knows, and we believe that the trial court's order must be reversed for multiple reasons, because we believe that every step of the analysis that was done by the trial court was in error. We start way back at the beginning from the analysis that was done of my client, Robert Schramm, whether he was a trespasser, whether he was a licensee, whether he was an invitee on the property. The trial court found that, and the only way it could have found this would be to find it's undisputed that he was on Adams Homes property, which was right next door to his. They had a new build going there for a construction project. The trial court had to have said it was undisputed factually that my client was on their property when this fall happened into the hole or depression that was there, where it is very clear from the facts, and actually the trial court even says that it's unclear as to where Mr. Schramm was, because the hole and the depression were sort of in the back corner and it's sort of right where property lines merge.
Well, in fact, the silt fence, let me get the facts right. There's a silt fence put in, right? And that would be right along the property line, I presume.
It did, Judge. There's a little bit of back and forth as to, because the silt line, the soil fence that was there was actually taken out as well. And so I think the evidence is fairly clear that the hole and depression that he fell in started on the Adams Homes part of the line. At least that's the best we know.
Well, painting the picture, there's a silt fence, and then there was and it got knocked down or something. It wasn't performing its function. Right. Apparently, I don't know. But and then the plumbing folks come in and they're digging, and the property owner is looking at all this going on, seeing there's a problem. So he decides to put some flags up. And he starts walking over there, and then and he didn't fall in the hole, but on his way to the hole, near the perimeter of it, it gave way and he fell 4 feet down into the hole. Is that sort of I don't know if it's uncontested or undisputed facts, but that's sort of what's kind of going on here. We're not quite clear where the property line is.
That's correct, Judge. Okay. And also, you're right that the client didn't actually sort of trip and fall into the hole. It was the ground that was around it, we believe, was compromised because of the fact that they were doing all this work. They were doing plumbing, they were doing sewer lines that were going in.
What were the injuries?
I'm sorry, what?
What were the injuries sustained?
The injuries he had, it was primarily leg injuries, knee, those ankle, those types of injuries that were there from the fall in the hole. As he
sprains,
went forward.
breaks, what was that?
I think it was sprains. I think it was broken as well. His ankle, and so there. I can look for you, Judge, and see and find out. Yeah, that's not something I focused on, but I can find that out for you, Judge, from the record, because it didn't really get into the injuries at that point. We know that he was injured when he fell in, and so by the trial court determining that he was on Adams Homes properties, where the facts, frankly, don't lend themselves to that, or at the very least are unclear, then from the beginning, the trial court is operating what we believe was on a flawed presumption. That he was a trespasser. They didn't owe him a duty. The only duty they owed him was this heightened standard to trespassers, that they couldn't do something intentionally.
I'm sorry, wasn't there some testimony that he went and tried to get the contractor to do something about it? He tried to contact him, and they wouldn't call him back, or they?
That's correct. No, he contacted the contractor, Adams Homes. He testified to it, and they didn't do anything. So he told them about the hole. I guess this was a hole. This wasn't something that formed like, within a split second. It was something that was forming. He contacted them about it, so they knew about it. They didn't do anything. And so as a property owner, homeowner, I guess for himself and others, he went out there to try to put the little flags, as you mentioned, Judge. It was before he got there that he was not aware of the ground that had been compromised below it. And so that ground gave way. That's what caused the injury. So we start from there, which we think just that part is error. Then we go to the part where we're talking about the duty to warn, duty to maintain. I'll get to the maintain later, but the duty to warn part, there is, the trial court found that, well, even if he was on his own property, he knew about it. It was an open and obvious condition. That's not quite what Florida law says. Florida law says that, yes, there is this concept of an open and obvious condition. It's sort of been subsumed within the comparative negligence part of the law. You can, the jury could say, you should have some liability for that. But what it doesn't do is it doesn't allow a judge at summary judgment to get rid of the entire case. Because part of the law, and I've cited to it in my brief, is that when a landowner, property owner, contractor in this case, possessor of land knows that there's a condition, even if it's open and obvious, they knows that that could cause injury to others, they have a duty to guard against that. So there's a duty under the law, even if there's an open and obvious. The classic example, Judge, is, you have a big sinkhole in the middle of Walmart that opens. Walmart can't just say, well, everybody knows about it, so if somebody falls, we don't have any liability for that. They do, because they know that, okay, people might be transversing in the area. It just so happened that it was the property owner next door that did, on his own land, we believe, but the duty is still there.
Right,
so,
and counsel, I apologize. With the Walmart example, I guess maybe I would agree that the law is not so clear for open and obvious, and there is that foreseeability component there. But here we have that, you're not a business invitee because you're not in the middle of Walmart. But the order seems to be sort of internally inconsistent. With whether or not he was an undisclosed trespasser, but then we don't know where he is by the order itself. So do you think that matters? Does it matter? You didn't really challenge his status as a trespasser on appeal. So are you saying that he was in the zone of risk? That seemed to be the argument, or what are you proceeding under here?
Well, we did say that his status was unclear. So to that extent, we are challenging the ruling, because the trial court ruled as a matter of law, basically, that he was a trespasser.
Yes.
We say within the briefing that status was unclear because there was material facts that were in dispute on that. And so we are challenging that part, but I think I hear what you're saying, Judge Kilbane, is even if he's a trespasser, let's just say that there was undisputed evidence that said that, it still doesn't get there. Because in that situation, the hole in depression, and really more specifically, the ground underneath, started on their side. Started on Adams Home's side and came into Mr. Schramm's side. They have the duty, under the law that we've cited, to make sure that the things that they're doing on their construction site doesn't hurt people outside of the site.
That's the building code you rely on.
It's the building code, and it's also the cases, like I think it's the Worth case that I've cited, where it's not just a duty of care that a construction or an owner has on a construction site within the site itself. It's around it as well. And so when things that are being done on the construction site affect things outside of the construction site, they have the duty of care for that. Maintain, warn, all the types of things that we see under the law. And
It's maintaining a silt fence.
so it's maintaining a silt fence. Maintaining the ground, that's if this would be, if this ground had penetrated so much so that it went to the house and it basically causes Mr. Schramm's house to fall down. I don't think there would be an argument from them that, well, we're not liable for that because that's really his house. It's not on our property. They caused that to happen. It's no different than causing something to happen that compromises the ground on Mr. Schramm's property that causes him to fall into it, literally.
As we sit here today, are the facts so definitive and clear that the injury occurred on the neighbor's property, not his property?
I don't think they are, Judge. I think when you look at the record, Mr. Schramm talks about coming from his property and sort of approaching the hole on his property, and that the hole had already kind of, he thought, kind of went into his property, and he's trying to do that's all, he's pretty clear that he's saying that's all on his property, that he's doing that. Now, there was some testimony about, well, are you sure? Do you know where your property lines are? And he, I think to his credit, said, well, I don't know where the property lines are, but I mean, I'm going there as to where it is. There was not, so he has that testimony. Adams Homes then comes in and says, well, he must have been on our property. I don't really know where that comes from, frankly. I guess the only thing it could come from is that, well, the hole was on our property, which is kind of a weird way to try to say you're a trespasser. But there really wasn't evidence there. And the court, I think, doesn't need to go any farther. I think, Judge Kilbane, you talked about or maybe it was Judge Makar, you talked about the inconsistency within the trial court. There was. The trial court literally said, well, I think that's not undisputed. I think there's a genuine issue as to where he was, but then went the other side and said, but it doesn't really matter. Well, we think it does, Judge. So there's multiple parts, like I said, from the beginning, that the trial court was inconsistent. The court made conclusions of law that were not supported by the facts. And when you get to the end of it, it's error. Cumulative, singularly, all together. So we believe that is why the court should reverse the order. I know have more time left, but unless the court has any questions for me, I'll sit down and reserve the rest of my time. Thank you.
Good morning, may it please the court. Therese Savone on behalf of Adams Homes of Northwest Florida. This court should affirm the trial court's order granting summary judgment in favor of Adams Homes. Judge Kilbane, I'd like to start my argument with a question that you posed to my colleague on the other side. You noted that he as in Mr. Schramm, was not a business invitee, and that's correct. He was not a business invitee. He entered onto the property, assuming this is Adams Homes property, without Adams Homes' knowledge or permission, and Adams Homes never learned that Mr. Schramm was on that property within 24 hours preceding, and that's the definition of an unknown trespasser.
Well, counsel, what's the record evidence that we know that Mr. Schramm was actually on Adams Homes property and not his own?
Admittedly, the evidence is not clear where it is, and that, as you indicated, that is in the trial court's order.
Is that not material to our determination at this stage?
No, Your Honor, it is not. The location of where he fell is not a genuine issue of material fact. It would be
How can that be?
How is that possible?
How does that not directly affect the duty of care owed if he's on his own property? Does that not give rise to an argument the failure to maintain the fence or other aspects of the construction site caused soil on his property to give way, and that's what he fell into? I don't understand how that's not a material fact.
Because if we look at the third amended complaint, Judge Soud, the allegations are for premise liability, and the allegation at page 119 in the record is that plaintiff was an invitee on Adams Homes' property. So I know my colleague indicated that, well, we don't know where Adams Homes came up with the fact that the hole was on Adams Homes' property. This was how it was pled. This isn't a construction defect case. There are no allegations related to the building code, and I know there was discussion about that in my colleague's brief.
Was there no claim for negligence?
There was
in
a
the
claim
third amended complaint?
Yes, Your Honor, there is one. There are two allegations against Adams Homes, and one is for premise liability, and one is for negligence. I acknowledge that. The invitee, however, and when we say where does it come from with where the hole was located, it was because of how the allegation was brought. So this is not a failure to comply with the building code. This is not a failure to go through the property. There are no property allegations. The allegations are that this is a premise liability, that Mr. Schramm was an invitee on Adams Homes property. And there is no evidence that he was an invitee. And Mr. Schramm testified that he essentially was not an invitee.
Did the negligence count say that as well, that he's an invitee?
I can double check that, but I do know that on count 1 for the premises liability, Your Honor, I do know that that indicates that he is an invitee.
Well, and I'm looking at page 122 of the record, which is count 2 of the third amended complaint.
Yes, Your Honor.
And at the bottom of that page, the allegations include paragraph 20 sub C, negligently failed to train or adequately train its employees to properly maintain its construction site, which compromised the safety of the plaintiff as he walked on or around the construction site. It seems to me, and I could go on reading further that negligence, it seems to me that perhaps that properly pleads and places into issue whether or not the failure to maintain the construction site causes a degradation to the plaintiff's property, depending on where he was at the time of his fall. And it seems to you seem to concede that that's actually not entirely clear as to where exactly he was on whose property at the time of the fall, which seems to me a quintessential dispute, genuine dispute as to a material fact. I go back to where I started a minute ago. Given the totality of the allegations within the third amended complaint and the record evidence as it was presented to the trial court, how this is not a quintessential jury question.
And it may be more a quintessential jury question, maybe on that count 2 for negligence, and maybe not on the premise liability action. And maybe that is the question. And to be candid with the court, and this is a little outside of my brief, but to answer your question, a premise liability case on count 1 indicates invitee. I acknowledge, Judge Sowd, at page 122 in the third amended complaint that it does discuss that. And I think where the trial judge's order focuses is on the invitee status.
But the summary judgment was as to the entire case, right?
Correct, Your Honor.
So are you conceding error on the count?
I'm not conceding error.
Sounds like it.
I'm not.
Okay.
I'm standing on all the arguments in my brief, but I want to address Judge Sowd's questions that were posed to me and to be entirely candid with the court. And I'm not trying to present anything inconsistent with my brief, and I do stand on my brief for the arguments. And I think the other concern within my answer brief was that the allegations and the arguments in my colleague on the other side's brief was that these are passing statements and that there is a burden on appeal. And that is an underlying theme within my answer brief. So to stand here and make conclusive statements in a brief is not sufficient for a burden in terms of prevailing on appeal. That is understanding what the standard of review is and understanding that the trial court's order does come with a presumption of correctness as well. But to the extent, and as focused on in my answer brief, Mr. Schramm was not an invitee. He was an undiscovered trespasser to the extent it was on Adams Homes land. It is our position, as indicated in our answer brief, that it is not a genuine issue of material fact where it was located. I understand the court's position on that, and I do acknowledge that, Judge Sowd. I also acknowledge, however, that this was an open and obvious condition.
What was open and obvious about a piece of land that collapsed downward? No one would have known it happened unless they stood on it.
Mr. Schramm testified that he saw a hole for about a month in advance, and that he wanted to go see it and put flags around it. So his testimony was that he cautiously approached it. So it indicates, what the summary judgment evidence indicates, is that he was in a superior position to know what perhaps the status of the surrounding land. And I think what both parties agree is the hole had to have been on Adams Homes property because it's the construction site. I think we all...
He didn't fall in the hole, did he, counsel? He fell in ground that collapsed. There was green grass, and he fell under it. So the fact that the hole may very well be open and obvious, but how, as a matter of law, is falling through green grass, I guess, I don't know how far away from the actual hole, how is that open and obvious as a matter of law?
I think based on Mr. Schramm's testimony that he was aware of the hole, he was watching the hole, he was looking at the hole, and he knew when he was approaching it, he was doing it in a way that it was clear when he said, I cautiously approached this hole, or I cautiously approached this area.
So if he ran to the hole, that would indicate that he didn't know? So because he was cautious and thought, wow, the hole's getting bigger, maybe I should go, so no one gets injured, that somehow makes it open and obvious as a matter of law?
I think based on the facts and circumstances of this case, I think it is clear that Mr. Schramm was aware of the hole and that he was watching it, and that he even described why he thought the hole was becoming a type of figure, or how it was getting washed out, or what he thought should have been done. So it was clear that he was paying attention to this. I understand that that may not be the facts and circumstances of every case. I do acknowledge that, and I do acknowledge that this may be a different type of case than others, but this, in Mr. Schramm's testimony, he was aware of this hole, he knew of it, and he was aware of it for a month. So that is exactly what the trial court looked at and said, this is what we're looking at to determine that this is open and obvious, because someone who can have their normal senses and perceive it. It's no different than if you have a landscaping feature, where landscaping features are determined to be open and obvious.
So a planter, you're saying that that case, I assume you're speaking of, that was a planter, correct? Like a palm tree planter?
I'm speaking generally, Judge Cobain.
Okay, so you think that this is similar to landscaping? Is that the best case you think that supports the position that this is open and obvious as a matter of law?
I'm saying that based on Mr. Schramm's testimony, it follows the case law that says if someone can perceive it with their natural senses and observe it, then yes, that is open and obvious. This is also not a situation where he had to take that route. He chose to take the route. He voluntarily went to it knowing that there was a hole. So my understanding of the evidence is not that you have a hole and then 20 feet behind he falls into it. This isn't an instance where all of a sudden it's a sinkhole. It's not that there's these unknown parameters where he takes a step, he thinks he's 50 feet off of a hole, and all of a sudden it gives way.
But is it akin to that? I mean, if I recall the record, and please correct me if I'm wrong, but if I recall the record correctly, he has a shovel in his hand.
Correct.
Designed to kind of probe the ground to make sure it's firm underneath him.
Correct.
And as he approaches an area that still has grass on it, it gives away. That's his testimony. And then there's some lacking clarity as to precisely where he may have been and things of that sort. But I mean, the picture that's painted, it seems to be kind of like as he's probing, in order to, with flags, mark the perimeter of unstable ground, he then falls. If grass is growing and covering ground beneath that is unstable, contributing to a fall, as alleged, we're not making that determination, but as testified to based on allegations within the complaint, I think I'm building, frankly, on Judge Kilbane's question. That can't be open and obvious as a matter of law. That would seem to me to need to be resolved by the jury. That's what I keep grappling with as I reviewed the trial court's order, as I reviewed the record in the case. That which is open and obvious, if it were undeniably undisputed on a whole on the construction site, that may be one factual scenario, but it just doesn't seem that factual scenario is presented in the record before us, and that's what I'm wrestling with.
I understand, Judge Soud, and again, I'm resting on my answer brief where we have argued that Mr. Schramm, and you are correct, he approached it with a shovel, but he approached it with the shovel knowing that he himself thought this was unstable ground.
Is there grass growing on the construction site?
I know that there are very black and white blurry pictures in the record. I know that there is grass, I can tell from that picture.
Okay.
To be 100% candid, cannot advise where there is grass or there is not grass.
On the Adams construction side of the line.
I cannot tell. I personally cannot tell from the pictures. But there is grass.
Did not an Adams construction employee testify that even he couldn't testify where the property was in a given picture?
I believe.
In other words, as it pertains to where a picture showing there was not a way for at least that one employee to say the property line is here such that it could be determined whether grass is growing or the like.
Right. It is, what we know from the record is that, and even in the judge's order, we know that the property line, it is not clear. Mr. Schramm doesn't know where he was. He even testified, he thought he was on the property, he wasn't sure. Obviously, if he falls into the hole versus unstable ground that may have been further off of the hole is on Adams Homes property. That we would know because that is where the construction and the plumbing was done. That is where the pipe was in the hole. So the hole has to be on Adams Homes property. He's not alleging that that hole was, they dug in a wrong place. So we know that the hole has to be on it because it is an active construction site. Now, where he fell in relation to that hole, I don't think anyone can say it is definitively on this. I do know that the argument related to the invitee versus the unknown trespasser goes to the premise liability, as in count 1 of the third amended complaint, where it was pled that Mr. Schramm was an invitee.
I'm getting a little confused now. Was this hole dug, or was it because of the overflow of water, or was it because of the plumbing, or why was there a hole? Put aside the collapsing sod.
Right.
Why is there a hole?
My understanding is that there was a hole because there was plumbing that was performed by the subcontractor and that there was a pipe within the hole.
Okay.
And it is my understanding that there was water or rain. According to Mr. Schramm, he believes it's because the hole wasn't properly backfilled, was his statement, that's why he believes that the hole got bigger. So there was a hole for plumbing on the construction site. So whether he fell in the hole or around this area, I think is where the question is.
Were there leaky pipes or something that was undermining? I'm trying to envision what happened to cause the sod to be undermined.
I am not aware of any evidence or testimony that there was a faulty pipe, leaky pipe, a crack in a pipe or sewage line or a water line that was being put in to the construction site.
Going back to the theory of the case with the 2 counts, my recollection, I could be wrong, the duty to the open and obvious doctrine basically can nullify a claim basically for a duty to warn type of situation. You don't have to put up a sign, warning the sidewalk has a 6-inch ledge. You know, it's open and obvious. So there's no duty to warn about that, under
Right.
the duty to warn theory. But that doesn't mean that all claims for negligence, meaning make the property safe, go away just because there's an open and obvious problem, open and obvious risk, let's put it that way. Isn't that the case?
Well, I know that when you have an invitee, and whenever we talk about premise, we have to look at the status of the land. An invitee you have a duty to warn, a duty to maintain. And I understand that one can go away and one can remain. But this case, there is no evidence that he was an invitee. And I think that's where the discussion was because, and I don't.
But that goes back to the fundamental issue of whose property was he on. If he's on his own property, he's clearly an invitee on his own property. So, I mean, he's entitled to be there, let's put it that way.
He's entitled to be on his property, absolutely. Whether he's now, but can he claim an allegation or a cause of action against Adams Homes, that he was an invitee on Adams Homes land, and then allege that it wasn't on their property? I'm not sure about. And I think that's maybe where any confusion in this case lies, was that the allegations, at least as to count 1, is that he was an invitee. So I know that there was the discussion of where did this come
Isn't
from?
this just a classic negligence case, comparative negligence case, where the jury says, okay, this hole was dug, it had some problems with it. He went over there, maybe he shouldn't have. We're going to balance it out and, apportion negligence. Isn't that this classic case of comparative negligence?
Judge Makar, I disagree for the reasons stated in our answer brief, which is that there was no duty owed by Adams Homes and that he was an unknown trespasser. And to
Were there any evidence that he thought he was putting flags up not just to warn people, but also to demarcate the risk and also perhaps to protect his own property?
I don't recall anything that he was doing it to protect his own property. I believe his testimony was that he was placing the marking flags because he didn't want someone to fall into the hole, which means he understands and appreciates with his senses where the hole is. So that's why, and I think what our discussion, Judge Kilbane, was the discussion of if the land gave way, his testimony doesn't indicate that it gave way so far away from the hole that it says, well, this clearly had to have been on his property. It seems more that this is pulling closer to or on the construction site.
But how can we say that as a matter of law at the summary judgment stage if there's not record evidence of where he fell? And no one is disputing that he fell into the hole. He didn't. It's not, I don't think, as far as I could tell in the record, it's not like he walked up to the hole and jumped in and then, or fell into the open hole. He was walking up to mark the edge, and at some point before the edge, the ground collapsed underneath him. So that's my question, as a matter of law at this stage, where we don't know if that collapse was before the hole, like how far before the hole, where it was, whose property it was on. I'm unclear how, as a matter of law, that determination is made with the record evidence in this case.
And I understand. And again, I do want to rest on my arguments in the brief, and I'm not trying to present any argument that is different than those that have previously been presented. So it is our position that this hole was known. He voluntarily went to this hole. He knew of it for a month in advance, and he was aware of it growing. Based on that, he understood what risk was there. And if he was on Adams Homes property, then he was an unknown trespasser. And to the extent that if he was on his property, we do not believe that any question is a genuine issue of material fact that needs to be resolved by a jury. We also stand on the position that these arguments and positions were not fully briefed to the extent that it would meet a burden on appeal by Mr. Schramm. And for these reasons discussed here today and those in our answer brief, we ask this court affirm.
So Adams Homes doesn't own the property, correct?
Adams Homes does own the property.
Does own the property?
Yes, Your Honor.
Okay. I was just,
Yes.
Is Adams Homes indemnifying the plumbing company? Because they're not here today. They were part of the summary judgment.
I am not aware of the answer to that, but
Okay, so I'm just trying to figure out where the plumbing company fits in, because they're not here. They didn't file a
Correct.
brief.
correct.
Okay, and you're not, they didn't, okay. You're not representing.
I'm not here on behalf of the plumbing company, Judge Makar.
Thank you.
Thank you.
Couple of follow-ups. Judge Makar, I did look, and the injuries that I was thinking of were an Achilles tendon injury that he had on workers' comp, and I think that had been aggravated. But the main injuries that he had was his right shoulder. I think partly because of the shovel, he kind of used as a brace, and that hurt. We had surgery from that. He also had low back injuries as well, and hip injuries from sort of falling into the grass. The other question I wanted to, right at the end, about the plumbing company. In the record, there is a contract that is between the two, and there is indemnification proceed in there. However, there also is certainly that the owner has non-delegable duties, right, to maintain and the property, and so we didn't choose to bring the plumbing company into the appeal, although they were part of the summary judgment, for that, but it was really more focused on the owner. The testimony, I think, that the court read or that was alluding to, it's pretty clear that this was not a step into the hole, that this was a falling through grass that was as he was walking towards, and I think the record also, I think it's page 296, I believe I had, of the record talks about the reason why he was doing it was that he didn't want his lawn maintenance people, and one of the reasons. He talks about, I wanted to put little flags because I didn't want my own lawn maintenance people who were mowing my lawn to fall in there to see it. So it's pretty clear. I don't think this was a situation, I don't think it was suggested, but this wasn't a situation where he's literally going onto the construction site and messing with a hole that he knows is on a construction site. That doesn't, frankly, make any sense, why he would be doing that. He's doing this because of the fact that he thinks it's on his side. He's worried about not only his safety, but of workers that could be around the area that he's hiring, as well as he's told them about it, and they're not doing anything. So I do agree, at the end of the day, this is going to be something that the jury's going to have to decide. They're going to have to decide how much negligence Adams Homes has, if there's any negligence that Mr. Schramm has, but they should get to decide it.
Would you be willing to address your colleague's argument concerning the absence of record as evidence as it pertains to the invitee status on count one?
Sure. As to the premises liability, yeah. So they certainly, as you can kind of guess from the way the Third Amendment complaint was done, they are sort of alternative pleading counts. If he was on, if the evidence was that he was on the property, that we would be saying that he's an invitee because they know about him. Right, there's evidence that they know about him as the property owner next door. There's case law that we talked about where, if you know that people kind of are around the construction site, you still have that type of duty. And so the facts of the case, we believe, could lend themselves to, frankly, either theory. That either he's an invitee on a sort of a traditional premises liability that could go under count one, but we also, as Judge, you mentioned, we included just the general negligence part of it. And that had to do with the fact that there was a condition that was created by them or for someone that was working for them, which ultimately flows to them, that affected his property and ultimately caused his injury. That's a pure negligence claim. We've pled that. I don't think there's any argument that that was not pled correctly or that could not have been brought to a jury. The judge just didn't allow it. He decided that because he thought that it was a trespasser, all the counts go away. And as we've already discussed, we believe that that was error. So we would ask the court to reverse on all counts and allow a jury to decide this.
Is there any evidence that there was an implied license to go on the property?
There's certainly, I don't, thinking through it, obviously there was, it's next door neighbors, literally. And there's certainly was the notice that was given to multiple people. I think actually he talked about giving notice not even to the owner, but the contractor, to the HOA association, I want to say. And certainly, when you start getting into whether someone's I think it's an uninvited licensee or an invitee, there's all sorts of permeations there. The facts certainly bear out those kind of situations. And when the facts are unclear as to the status of someone, a court can't determine that. I think that's the bottom line we have in this case. Thank you, Your Honor.
Thank you. Thank you both for your arguments. We will be in recess.